Welcome to How to Fix It. I'm John Avlon, author, journalist, historian, recent congressional candidate. And the point of this podcast is to focus on solutions to the problems we face, not simply to focus on the problems themselves, although heaven knows there are a lot of problems piling up. God knows there's a lot of those right now. This is a dangerous moment for our democracy. There is a persistent assault on the rule of law, a flirtation or perhaps a determination to compel a constitutional crisis. And this week, joining me to discuss it is Michael Waldman, president of the Brennan Center for Justice at New York Law School. We're going to discuss the invocation of the Insurrection Act, the determination to try to isolate an American resident in El Salvadoran prisons without due process, and the prospect the president has raised of shipping American citizens to foreign prisons. We're going to discuss the collective action problems when even law firms initially took the knee, and how to fix it, how to fight back peaceably, patriotically, to restore our democratic rule of law. Joining me to discuss all this and more and how to fix it is Michael Waldman. He's the president of the Brennan Center for Justice at New York Law School, former chief speechwriter to President Clinton. Michael, it's great to have you on How to Fix It.
Great to be with you.
All right. These are times that are piled high with difficulty, Michael. So first, I want you to offer folks a reality check of sorts on where we are with a sense of legal perspective on the road between persistent, deliberate assaults on the rule of law and outright constitutional crisis.
So from the first minute of the first day of his term, Donald Trump has consciously, I would say, broken the law, pushed the boundaries, put forward action after action that at the very least would challenge the courts and the rest of us to push back. On that very first day, for example, he signed an executive order purporting to end birthright citizenship, the practice that if you're born in the United States, you are a citizen here. And this is literally written into the Constitution. It is actually the purpose of the 14th Amendment. A president cannot undo it by executive action. That was one of the very first things he did. He can't think it'll be easy to get that past the courts, but it's one of perhaps dozens of actions that have tested whether the rule of law applies. His administration, people like Vice President Vance have argued that the rule of law doesn't apply, that courts or Congress or others holding them to account is somehow a violation of their prerogatives within the executive branch. We're seeing that tested out in a bunch of different ways across a bunch of different types of cases, and especially, as we all know, increasingly around the mass deportation and the efforts to use emergency powers to deport people without due process.
You're right, of course, to say from the first hour of the first day. In fact, I would argue it began before the first hour of the first day when he effectively overturned via a presidential statement not only a law around TikTok, but a 9-0 presidential decision that would have compelled its sale by January 19th. He has since pushed out that self-imposed deadline. So this is something that's been persistent from the giddy up, as you say, with vast implications. Now, in the case of a U.S. resident being mistakenly, in the administration's own words, deported to an El Salvadoran prison, and now being said that there's no way to get him back despite a court order. And in fact, the president saying on camera repeatedly that he wants to deport U.S. citizens to foreign prisons. Anyone who ever called themselves a constitutional conservative, anyone who ever said they were concerned about civil liberties from a libertarian perspective ought to pay close attention to this, because these are dictatorial powers unlike which we have ever seen in the United States. Is that right?
I think so. And if this claim of power by this White House simply sails through, there's no reason to think it is limited to people who they claim were in a gang or to immigrants. There's nothing stopping any administration from doing this to anybody. This individual, Mr. Garcia, was here legally in the United States. A court had previously said he could not be deported. The administration said, oh, yeah, it was a mistake. They fessed up right away, and still are effectively refusing to follow what the courts have been saying. Now, as you know, this is a maddening catch-22 situation where they say, oh, gee whiz, it's just El Salvador controls this individual's fate. And El Salvador, in turn, including in the Oval Office, the president of El Salvador, who calls himself the world's coolest dictator, he said, oh, this is an American problem. I couldn't possibly send this individual back. So you have a situation here where people are pretending they have no power, but it's testing the courts. The courts have made very clear that that this is wrong and needs to be undone. And you could well have a situation where the Supreme Court speaks with an even clearer voice than it already has and says this individual must be returned. But it's challenging because the administration will say, oh, this is the foreign policy power of the president. They will have many tools at their disposal. And your initial question of when will we be in a constitutional crisis, I think it's important that we all think about the fact that a constitutional crisis is not sort of a thing. It's not a light switch that one turns on and off. It's sort of a headline writer's summary of something that's going on. We are, at the very least, in a constitutional emergency right now because of the very overt eagerness of the new administration to break these laws, to put forward things that are unconstitutional, and to force courts to start responding.
So let's talk about that response. Famously, J.D. Vance during the campaign quoted Andrew Jackson, who said, I've read Justice Marshall's opinion. Now I invite him to enforce it. That is an invitation to a constitutional crisis. So the question becomes, what are the actual enforcement powers that courts have, especially given that the U.S. Marshal Service reports ultimately up to the executive? What role can civil contempt play? What are the levers that courts actually have that this administration might respect if they only respect strength?
Courts have considerable power, but it isn't only the courts, too, who have power in this situation. The fact that we cite Andrew Jackson, and sadly, I've researched this, there's reason to think this might be an apocryphal quote, but it's the one that everybody understands Jackson meant when he refused to follow the Supreme Court's order regarding Indian removal. And then there was one other time where there was a clear ruling from the Supreme Court during the Civil War where Abraham Lincoln didn't follow it. He knew he had done something wrong, and he quickly went to Congress to remedy it and get a law passed to make what he had done legal. And it's worth noting that that was pretty much the last time that a president thought they could just ignore a clear command and a clear interpretation of the law from the Supreme Court. That was a long time ago. Ever since then, we've all understood that presidents have to follow the law, and that the Supreme Court, when it makes a clear ruling of that kind, is articulating what the law is. And the challenge for courts is they don't have an army. They have the power of their credibility in the political system. So what powers do they have? Well, first of all, as you say, there's contempt. There's criminal contempt. The problem with that is that the enforcement of that is through the U.S. Marshals. You're right that the U.S. Marshals technically work for the Justice Department, but the law also says they are supposed to respond to the instructions of federal judges. So even that is a constitutional question. There's also civil contempt, and all of these can be held not just against the president, but against other administration officials. And there are examples, for example, where courts have appointed prosecutors to bring contempt charges against individuals when the government won't do it. In the case of Stephen Donziger, in the Chevron case, a judge was fed up with the Justice Department and appointed a prosecutor. And courts have some significant power here, but there may be some limits to it. I think it's really important that we not let Congress off the hook. We all take for granted now, oh, well, Congress, it's controlled by the same party as the president, so they don't have any role here. Well, that's really wrong. The ultimate power here is by Congress to hold presidents to account, to use all the tools that they have at their disposal, everything from budgeting to impeachment, to make sure presidents follow the law, and then ultimately voters. You also have situations where lawyers are being sent into court to make plainly disingenuous arguments on behalf of the federal government. These people are all subject to disbarment for misleading the courts. There are powers that the courts have, but the main power really is the belief that we all have and must have that the Constitution must reign supreme. That, as Thomas Paine said at the time of the founding, in America, the law is king. Part of the answer is to ensure that there is a free and fair midterm election next year. It's not very far off. At a time when the administration having begun with this kind of spree of executive actions purporting to give orders, many of which are illegal, now has begun to turn its attention to the election system itself. It's important to remember, John, a lot of these executive actions, some of them have significant power. A lot of them are just kind of like malevolent press releases. They really don't have any legal force. And they're designed to make a splash. An example of that, in my mind, is one recently that went after voting in the United States that purported to basically have the president, in this case President Trump, take over the election systems run by the states all over the country. That's illegal. The president has no authority under the Constitution to do that. It also ordered an independent agency, the Elections Assistance Commission, to follow his orders, which it isn't even legally allowed to do. And this order that Trump signed with a great Sharpie flourish in the Oval Office was said that you had to produce a passport, not even a birth certificate, let alone a driver's license, but a passport to register to vote in the United States, and also ordered the states to let Doge into the voter rolls with all the sensitive information there. Because, what could go wrong with that? Doge would, quote, find the fraud. It's not unrelated that the true sanction, which is the voters, is also the target of some of these unconstitutional actions.
Not unrelated at all. How do you see censures or sanctions, civil contempt in particular, that could be deployed against lawyers or members of the administration? How does that dovetail with the immunity decision written by Justice Roberts that basically gives any president, but in this case Donald Trump, apparently a get out of jail free card for anything he does as president?
We are seeing now the consequences of that decision, which I do think already should be seen as going down in history as one of the worst in American history. That decision, of course, dealt with a specific question, which was, can a former president be criminally prosecuted? Now, up until that point, everybody under the sun had said, yes, of course. The long tail of that immunity decision, which plainly is one of the worst in American history, is being felt now. That decision in Trump versus U.S. dealt with the question of whether a former president could be criminally prosecuted. Up until that moment, everybody said, well, of course. That ruling on its own terms was terrible. It said that if it was an official act, the president could not be prosecuted, which, among many other things, would have meant that Richard Nixon would have not faced accountability for most of what got him in trouble during Watergate. It was a kind of a how to break the law manual for law-breaking presidents. It said, if you want to break the law, just make sure to conspire with someone else who's also drawing a taxpayer paycheck. But there were things in that decision that were not quite about that ruling that are what we're facing. In the ruling, Chief Justice John Roberts said, the president is the only person who is a branch of government. The executive branch is the only branch of government that is a person. That is an extreme version of something called the unitary executive theory, which is the idea that the Constitution made the president as a person the executive branch. At its most extreme version, it means, it would be argued at least, that the whole rule of law doesn't apply to the executive branch. Now, that ruling didn't explicitly apply to people other than the president. But if anybody in the executive branch is the president, you could certainly say that it does. And then there's an even more dystopian version of this, which is, so some subordinate is ordered by the president to do something illegal. Say SEAL Team 6 is told to assassinate, the political opponents, as was the hypothetical in that case. The president cannot be prosecuted for that official act. Well, the people below him can be, but not if they're all just doing it as part of the personhood of the executive branch. And also, the court made clear that decisions on pardons could not be reviewed for illegality in the motive. And so the president could say, look, just do this illegal thing. You know it's illegal. I know it's illegal. Don't worry. I'm going to pardon you. So it is the dictatorial potential consequences of that decision are becoming more and more evident, and puts more and more of a burden, I would argue, on the Supreme Court to step up and do the right thing this year. I mean, it's been a really striking thing to see how many of the lower courts have been really strong in standing up to improper executive actions. I mentioned the birthright citizenship. 3 days later, a judge appointed by Ronald Reagan said it was flagrantly unconstitutional. There have been at least 46 rulings, temporary restraining orders, and other things of that nature by trial court judges. But now these matters go into the hands of the appeals court judges and the Supreme Court, which, as you know, is much more political. And so if they are going to live up at all to their rhetoric about the rule of law, about the Congress should decide major questions and other things like that, then the Supreme Court is going to be really put to the test. Are they going to step up and stand up against Trump's abuse here?
Our democratic republic depends upon that answer, it seems to me. Let's talk about one of the threatened and somewhat discussed powers, which is the invocation of the Insurrection Act of 1807. When Trump took office, one of his first actions was to have a 90-day review of whether he could invoke the Insurrection Act. The deadline for that is April 20th, this Sunday, Easter Sunday, as it turns out. There are folks warning that this could have dire implications if his internal review board, consisting of cabinet officials and appointees, were to say yes, that you could invoke the Insurrection Act. How likely do you think that is? Help people understand the implications of it, and then what can be done.
Well, so the Insurrection Act is one of these emergency powers that are lying around that have not been used very often, that give all presidents enormous authority and enormous power, and which Trump has promised to use in an abusive way, going back to the campaign. A lot of these laws go back many, many years. We've all learned about the Alien Enemies Act. That is the last remaining part of the Alien and Sedition Acts of 1798, which was the notorious set of laws abusing civil liberties that Thomas Jefferson said came from the reign of witches. That's the law that's being used to justify deportation of people without any due process. In other words, without them having to prove that they, in fact, need to be deported. The National Emergencies Act is a more recent law that, again, gives presidents lots of power. The Insurrection Act, which dates from 1807, these laws have a lot of dust on them. That is a law that gives an exception to the very strong rule that you're not supposed to use the U.S. military domestically. Now, occasionally, presidents use that power, proclaiming insurrection. For example, in 1992, there were riots in Los Angeles following the verdict in the Rodney King case where he was assaulted. George H.W. Bush used the Insurrection Act to send in troops to Los Angeles to help restore order. But it's for things like that. Here, what there's an expectation, and I don't give a lot of credence to the review that they're doing. I think that they're just waiting until the deadline is over, in all likelihood. The concern is that Trump is going to use this, first of all, around immigration issues. There's an idea, for example, that he might declare the use of the Insurrection Act all along the border. He might declare it a military zone so that if you enter the zone, you've committed a crime. The military has a limited role now in immigration. It's been allowed to be used to help the civilian immigration authorities like the Customs and Border Patrol with certain tasks. But the military has not been and should not be used to grab people off the street, to detain them and things of that nature. And the worry, of course, is that he will use the Insurrection Act for that purpose. A president can also use an Insurrection Act claiming that a peaceful protest on the streets is a violent insurrection. We know that Donald Trump wanted to do that during the Black Lives Matter protests in 2020 and that his military leaders said no. That hasn't happened yet. But around immigration, we know that from the podium during the campaigns, he and Stephen Miller and the others said they were going to do this kind of thing. It too will be a real test. And on those issues, courts in the past have not stood up strongly enough. They give the executive, whoever the executive is, a great deal of leeway to make that decision.
So if they come down on April 20th and they say that they have reviewed this internally and the Insurrection Act applies and the president has new blanket powers, what is the process? What is to be done? How to fix this? Is there, will courts review this? If people start protesting, there is, as you said, a danger that it could be used against them. So what are the fail-safes put in place?
We think that it would be illegal. I'm sure there would be lawsuits brought. It's also the case that the rest of the Constitution still applies. You still have your Bill of Rights to be protected. There's still freedom of speech. There's still all these other things. If presidents, for example, if this president calls out the military on peaceful protesters, that would be an extraordinary escalation. And again, the rule of law should apply. So I think what we're learning with all of this is when it feels like Trump is this just, unstoppable Leviathan, we've seen from the first few months that just isn't true. He's moving fast. He's got great power. All presidents have these powers. They've been restrained from using them by self-restraint more than anything else. But courts have been willing to step up to slow things down. The Supreme Court ruled 9-0, not in a definitive way, but unambiguously, that they felt that he was not following what he ought to do on this deportation issues in some respects. And Congress, again, I think it's really important that we not let Congress off the hook. Congress has tremendous power here, and it's not enough to say, oh, well, they're in the same party as the president. Congress is supposed to be a co-equal branch. It's supposed to be the preeminent branch. And all of us will be remiss if we aren't demanding that Congress act to rein in the president on things like this.
Yeah, but meanwhile, back in reality, the truth is that hyperpartisanship's a hell of a drug, and this Congress, the Republican Congress, has completely ceded its power to this Republican president in the name of hyperpartisanship, in the name of power. I wish that wasn't the case. The founders clearly thought that self-interest, rational self-interest, ambition must be made to counteract ambition, would provide a check on that would have a balance of powers effect. But that's broken down, hasn't it?
It has, but reality still has some purchase here. In other words, the president in the tariffs, he claimed. It's always the question of, wait a minute, how does a president have the power to upend the world economy by himself? And the answer is he doesn't. He did this claiming another set of emergency powers, basically claiming that the trade deficit was an emergency. But the Constitution very plainly gives Congress the power to set tax policy and tariff policy. And there's, in fact, litigation brought by very conservative groups, backed by Leonard Leo of the Federalist Society and the Koch network and others, saying that this is a violation of the law, that what he has done on tariffs. And similarly, people support, the voters support strong immigration policy. I think it's fair to say that they were rejecting the immigration policies that the Democrats pursued. They want a protected border, but people don't necessarily want bloodshed on the streets either. And they don't feel very good about the military patrolling the streets. And we have seen that when there are flesh and blood examples, such as Mr. Garcia and what's been done with him, that people actually do rise up. So I don't think the laws of political gravity have been repealed.
How long do you think it will take for those various suits challenging the constitutionality of the executive imposing tariffs in contravention of the Constitution, invoking the Emergency Powers Act? I mean, how long will it take for that to be adjudicated?
Some of it will happen fast, and some of it, as happens with lawsuits, will happen very slowly. We at the Brennan Center, which I run, have something called that we're calling the Constitutional Crisis Litigation Project. A lot of what we do is we work with others. We have not, by and large, brought the cases that I mentioned that have gotten these temporary restraining orders, although we have brought a case challenging the voting executive order directly on behalf of the League of Women Voters with others. But, so many of these cases have been brought and won by groups like Democracy Forward. Now they're in the appeals courts. They're heading to the Supreme Court. Some of this stuff is done by the Supreme Court on what's called the shadow docket, which is an ominous name for when the Supreme Court makes a decision without hearing a case, basically allowing a lower court ruling to stand or changing a lower court ruling without all the full arguments. I think there will be some major rulings this year, this June, this July. And I think some of these are things where the more stately, normal pace of the Supreme Court will kick in, and we won't hear these things until hear these decisions until the spring of 2026, just in time for the midterms.
So let me pause you right there. Knowing the court as you do, and you've written a number of excellent books, including one I recommend everyone on the Second Amendment, including one on the Supreme Court. When, as the Trump White House just did, basically mischaracterizing, gaslighting, in effect, a 9-0 decision to say it was in their favor when that was not evidently its intent. What is the Supreme Court's role in clarifying that you can't simply, have magical thinking when reading a piece of paper and say it backs you up when it doesn't?
Well, you're exactly right. Sooner or later, the Supreme Court is going to have to face up to their responsibility to speak plainly, to put some teeth in their rulings, and challenge the president to follow or not follow. It's an interesting thing. I and many others, of course, are concerned about all the noise and rhetoric from the administration about, we're not going to follow these court rulings. That's an intrusion on our unitary executive power and so forth. Vice President Vance, Elon Musk, both tweeted versions of that after some of these rulings. Interestingly, though, the president has said repeatedly, oh, no, we follow court orders, we follow court rulings. And in fact, when they go into court, the lawyers for this administration say, oh, yeah, we follow court rulings. Now, it's something of an open question whether they really are. They didn't turn the planes around when the judge ordered them to. And you're right that Trump dealt with this contradiction the other day just by gaslighting and saying that a ruling that was a 9-0 ruling against him was really a 9-0 ruling for him. But there was enough, fuzziness in what the Supreme Court did that he got away with it. But sooner or later, they may be forced, I think they will be forced and should be forced to kind of draw a line. The Supreme Court is a political institution. Don't get me in trouble for saying that, but they're not deities. They're not a religious order. They're a political institution. And it is plainly the case that they try to shy away from conflict with the other branches when they need to. And a lot of the things they've done up until now have been things to give a nod to what they think without actually, forcing the issue. And there's always, the worry, if we rule too definitively and Trump just ignores us, then we'll reveal our powerlessness. But sooner or later, that's what a court has to do. And it would be uncharted territory if the Supreme Court made a definitive ruling on one of these issues and the White House just said, well, the hell with that.
Well, again, they've given every indication that is their intention, their desired destination. We will see. A lot hangs certainly on Amy Coney Barrett and Justice Roberts. But in the spirit of how to fix it, we've talked about civil contempt, criminal contempt, these lawsuits that are being put forward by a variety of groups. This is not left, right. This is right, wrong. Let's keep remembering that. But really, it comes down to collective action. And I want to ask you on your thoughts about the initial failure of collective action when it came to targeting and demonizing law firms. The reporting was that basically when certain law firms were sanctioned, singled out by the president for these draconian sort of not only removal of security clearances, but access to the federal courts, that other law firms saw it as an opportunity to get competitive advantage. Now, subsequently, we've seen a large number of smaller law firms band together in collective action. But are you surprised that lawyers and heads of law firms felt the need to take the knee in contravention of all their larger oaths? And what are the lessons to be learned about the importance of collective action at the outset?
I think that the failure of collective action was dramatic, and that things would have turned out very differently had the law firms acted differently at the beginning. As you remember, the first one of these executive orders that targeted a whole law firm was at the law firm Perkins Coie. And it was kind of shocking. And this was a whole month and a half ago. There was an expectation, not just a hope, that the entire very powerful law firm industry would step forward. And in fact, that there was an expectation that a few law firms would represent Perkins Coie. That didn't happen. In fact, the top law firms in revenue, the biggest law firms, wouldn't even sign a friend of the court brief backing them up. A few of the major firms, Jenner and Block, Wilmer Hale, have stood up, have fought back, have sued. Wilmer, for example, is being represented by Paul Clement, who's one of the leading conservative lawyers in the United States. But a lot of them have cut these deals where they basically have said that they were going to turn over their pro bono practice to Donald Trump, who's now the director of pro bono activity at some of these firms, evidently. Trump announced that he wanted them to all work for the coal industry fighting environmental regulation, which, honestly, they do that for pay. I don't know why they would do that pro bono. But so, one at a time, it was a lot easier to pick them off. Similarly, when the administration went after Columbia University. Now, Columbia has had dreadful problems of anti-Semitism at that campus, and those are quite real. But the demands that were made by the Trump White House of the university were outlandish, and they felt it necessary in order to preserve their funding to give in on a lot of them. And then it actually hasn't helped them very much because they're continuing to get this pressure. Now we're seeing universities like Harvard, like Princeton, and others standing up. And I think that courage is contagious. And I think we're starting to see big, powerful institutions stand up. There needs to be more of it. We all have reason to worry that nonprofit groups are going to get targeted. They've said they're going to go after the tax-exempt status of Harvard, for example. It's very important that we understand that civil society is being targeted. It's not any one group. It's not the Vera Institute had its grants taken away, well-known criminal justice policy organization. This is not about any one group. It's about an attack on an entire civil society. And the more we all stand up together, the stronger we will be. And over time, I think this will be repudiated.
So let's talk about how, in the spirit of how to fix it, because as you said, some of the institutions that acquiesced early found that they made a deal with the devil, in effect, that their demands did not end and they did not get their money back. So it shows that courage may be contagious, but cowardice is also when you make that initial concession, bullies only respect strength. What does that collective action look like on the part of institutions that are being targeted in their finances? What does that collective action look like in terms of citizens defending civil society? That's, I think, what would be very useful for people to hear and know right now.
We all need to speak up. We need to make this a political issue. We may not love these big, very wealthy universities, but we need to speak out. We need to speak out when nonprofit groups and others are targeted. The things that have helped shift the political dynamics a bit in the last few weeks range from the judicial elections in Wisconsin, where Elon Musk poured a great deal of his personal money into trying to elect one of the candidates for that opening, and the other candidate won in a walk in what was seen by everybody there as a referendum on Trump and Musk in a state that Trump had just won. The demonstrations on the streets the other day were important and put forward a compelling and very positive picture of people responding. I think that big institutions like Harvard, with all of its cachet and its endowment standing up, makes the point that actually government, everyone acknowledges that so much of this stuff is illegal. The worry for these law firms, for example, every one of the law firms that has gotten targeted with one of these executive orders, who has gone to court, has won a temporary restraining order saying this is illegal and you can't take away the ability to go into government buildings and all this other kind of stuff. But the worry was that the clients, the companies that employ these law firms would be scared off. I think the more collective action there is, the less of a chance that clients will be scared off, because they'll see that it's not, oh, well, I'll go to one law firm or another, or I'll go to one nonprofit group or another, but it's an attack on the entire civil sector. I think the administration is overreaching it pretty badly, pretty dramatically, and coupled with the economic, chaos and the bond market and everything else, I think there's a chance for an effective pushback without knowing fully what it all is. There's no one magic button to push or single strategy, but the louder we get, the stronger we will be.
Courage, collective action, stepping up, because now is the time to step up and to demonstrate courage. That seems key, because trust, faith in the rule of law is one of America's greatest strengths. It is, in fact, at the end of the day, one of the things that makes America truly great and a democratic republic. Michael Waldman, president of the Brennan Center, thank you so much for joining us on How to Fix It.